Okay, we shall start now. Ramya Devi.
Yes, sir.
Yeah, we can start.
Good morning to one and all who are presented here. The world is full of diamonds and gems, and we are having some of them here today to build this event. With this note, I would like to give my heartiest welcome to our chief guests, professors, and my dear friends. We need your support to make this event more memorable and fantastic. Now, I would like to invite Ms. Pavitra, MBA, IEV, second year, to give your welcome address.
A very good morning to one and all present here. On this auspicious day, I would like to welcome you all for this lecture. It's an indeed great pleasure to welcome you all who are gathered here. On behalf of Puducherry Technological University, I proudly welcome you all for this online series of lecture. I warmly and respectfully welcome our resource person, Mr. G. HANEESH KRISHNAN, IP lawyer, for attending this event in his busy schedule, and my genius welcome to our coordinator, Dr. B. Hemakumar, IIC convener, Innovation Ambassador, Cherry Technology University, for conducting this event in a successful manner. Last but not the least, I would like to welcome all the budding entrepreneurs and participants for making it an enthusiastic lecture.
Thank you, Pavitra. Now, I would like to invite Dr. B. Emakumar sir, IEC convener and Innovation Ambassador for presentation address.
A very good morning to one and all present over here. I'm indeed very happy to propose the presidential address for this session. So we all know we have a very superb title today, patent drafting and prior art search. So we all know an idea can be worth millions if it is executed well. Okay. Patent drafting is the first step to protecting a great idea. But to reap the monetary benefits as an inventor, you would first have to mark your exclusivity of your invention. This is where the subject of intellectual property rights comes into picture. So today we have with us a superb person, a IP lawyer. Okay, so Mr. HANEESH KRISHNAN sir today is going to share with us about patent drafting. Of course, it's a very big area. It's an ocean actually. Definitely it will be very challenging for him also, because in a short time he's going to touch upon all the important aspects of patent drafting and how to conduct a prior art search. Okay, so that will be quite interesting and very much needed of the hour, because nowadays wherever we go we want to commercialize our idea. So how to commercialize? So that's where a patent comes into picture. A patent is a kind of an intellectual property. It's a very powerful legal and technical document which gives you the exclusive rights to commercialize your idea. So that's where so we have chosen this lecture as part of the impact lecture series. Definitely it will create a greater impact. So I thank once again HANEESH KRISHNAN sir for accepting our invitation and is come all over the way to present here. Thank you very much, sir. Thank you. Ramya.
Thank you, sir. Now I would like to invite Ms. Raghavi, first year MBA IEV, to give your intro for chief guest.
Good morning to all. It's a great pleasure for me to introduce our chief guest, Mr. HANEESH KRISHNAN, to the impact lecture on patent drafting and prior art search. Mr. HANEESH KRISHNAN is a IP lawyer. He has huge experience in intellectual property rights, both in the prosecution of application and also to proceed with complaints of IP issues. He has 20 years of experience in working law firms and technology companies. He handling patent, design, copyright, and trademark application in India and internationally. He also handled Patent Cooperation Treaty (PCT) applications and closely worked with foreign associates to file patent and trademark applications globally. He supports startups in Karnataka and Kerala for protecting their intellectual property rights. It's an immense pleasure to have your presence, sir, and thank you for accepting our invitation. Now, I invite him to take over the session.
Thank you. Thank you very much. Am I audible?
Yes, sir.
Okay. So good morning, everyone, and thank you very much, Mr. Hemkumar, for giving this opportunity. And I also thank PEC for this wonderful opportunity to address the young blood, coming budding entrepreneurs. And I have from last 20 years experience. I could see it now. It's like a booming, time for all these startups and young entrepreneurs to come up with their ideas. So I'm very happy to join your this particular session, and very happy to share my knowledge and experience on IP. So I think it will be very useful for for you guys. And my colleague Mr. Santosh also joined. He's a patent engineer, experienced patent engineer. He supports me for drafting and and doing the prior art searches. So he's traveling, so I think he won't be able to switch on his video, but he's always available here.
Good morning, everyone.
So excuse me. Okay. So you will be aware of the basics of intellectual property, as Mr. Hemakumar mentioned, in the current scenario of intellectual property, right? Especially for startups, because startups, when you come up with a startup, we don't have any assets for the company, right? So, our assets will be intellectual property rights, like trademarks, patents, copyrights, designs, etc. So when you go for right now, what we see, practically, we could see all these companies coming up, startups coming up with their ideas, and they are confused what type of IP they would like to protect. Whether it is a patent or a trademark, it can be a design or a copyright. They are confused. So the basic here, what it's a awareness program where basic thing you should when you come up with some innovative thing. It can be a name, right? It can be an idea. It can be a shape of a product. It can be some artistic work. So we being a young entrepreneurs, like a freshers coming out from the universities, they are not aware how to protect this particular my intellect. So these are the areas where we try to share our thoughts and experience on how to protect this IP. So we are here today. We are just brushing you through the basics of the prior art searches or patentability search, or the how to draft a specification, a provisional or a complete specification. So I think Santosh will taking care of all the prior art searches, formalities, and drafting part. So I'll just brush you through the basics of IP. It's a very basic thing, I don't want to because this is a very vast area, and it is very deep, and within 1.5 hours, it's very difficult for us to provide you the details, the complete details about the prior art searches and drafting. Patent specification drafting. So I'll just brush you through the basics of IP. As you all know, IP, the basic, like IP is combined of trademarks, patents, copyright, designs, geographical indication, trade secret, etc., etc. So for entrepreneurs and the companies, for us, the main IPs what we may come across are like trademarks. As you all know, what is a trademark? Like a trademark is like protecting a name of a company, firm, or establishment, which will help the public to distinguish our products or like our services from others. So it's a unique name. Basically, for a trademark, when you select a trademark, a name of the organization, it should be very unique, and it should be a coined word. It should never be a dictionary term or generic terms. It's always good to avoid these kind of generic terms. So it's about the trademark. So that is a type of a registration for the trademark to protect your name of the organization. The next part is like patents. Patents, I think I'll bring it last. Design. Design protects the outer shape of the product. It doesn't have anything related to the technicalities or functionality of the product. It is just the outer shape of the product. The shape of the product can be protected under the Design Act. And next comes the copyright. Copyright is like, if you have any kind of artistic, literary, or any software or something to be protected, so that can be protected under the Copyright Act. So here also doesn't have anything related to the technicalities or functionality of the product. It is like if you have a artistic work or a literary work, if you have come up with a song, lyrics, like movies or anything, any kind of expressions can be protected under the Copyright Act. And next comes our patents. Patents are like, any idea, sorry, any idea, you're coming with an idea which is having industrial application, innovative factor, all these things, as per the Patent Act, whichever is not patentable, if you are not coming under that not patentable category, then those ideas can be patented. That's a very simple term I am using because we don't have much time, right? So I think Santosh will be able to help you out with getting into more detail about the prior arts and about the patents part. Santosh, are you there?
Yes.
I'm there. Okay, so I think I have just brought you through the different types of IPs which are very useful for the startups or entrepreneurs. Young entrepreneurs should know. And I think we'll go ahead with the your session, Santosh.
Yes. Will you be presenting, Hanish?
Yeah, I'll share the PPT.
Yes, please.
Okay.
So hello everyone again. I'm sorry for not switching on my video due to lack of network. I'm unable to use it or unable to even discuss properly. So please bear with me. I've been closely associated with Hanish for past 4 to 5 years, and we are working together. And I'm a patent engineer. So, Hanish, I think I'm unable to hear you.
Anish sir, we are unable to hear you actually.
You can't hear me right now?
No,
Yes, we can hear.
Okay. Are you able to see my screen?
Not yet.
I think I'm not getting access to share this.
When you meeting goes, you can share actually. Present now option is there on the down.
Yeah, present now is there.
You click on that and you can have the either entire screen or a window. You have an option if you click on that.
Okay, yeah. So is it visible now?
Yes.
Okay, fine. Yeah, Santosh, you can take it from here. Yeah.
Thank you so much, Hanish, and thank you so much, everyone, for this opportunity. Firstly, so as Hanish mentioned, he's already covered the basics of intellectual property, the types of intellectual property. So we'll be going into patent search and patent drafting. So next slide, Hanish, please. So these are all already covered, where intellectual property is nothing but an asset or an idea that has been created in your mind, the intellect. So it's basically a creation of your mind. So by safeguarding or by protecting this idea, you can actually prevent someone from copying. That's the main agenda of intellectual property rights. So you are stopping someone from copying yours, and in the process you're also making some financial gains through that. And it is similar to a real property. It's similar to what you see as real estate. It's similar to that, and sometimes it's even more valuable than that. Depends on the technology in which you have actually in your idea is on. And next slide, please, Hanish. So this is what it fosters innovation. As you can see, even a monkey can use telephone. I mean, the smartphone now. So, and I think it's even using iPhone here. So it fosters innovation. That's the main purpose of it. As you know, industrial revolution actually started in around 1700s or 1740s, if I'm not wrong. So from then on, we have come a long way from just starting to make an engine. Now we are even going from internal combustion engines to even now hybrid engines or even hydrogen operated engines. So this is what the patents or technological evolution leads us to. So constant improvement in technology so that our quality of life and as well as the way in which we perceive life changes. So social and economic growth is also inherent to that. So upon protection of the intellectual property, the main thing again is to compensate for their work, and that is through financial gains here. And if one competition is working on some technology, the other competition also works towards it because they want to show that they are competitive enough in the market. For example, in the smartphone segment itself, or even network segment itself, you have so many players in that, so many market lead. I mean, so many companies are there which are just working together and bringing out different products with minor changes. So, next slide, please, Anish. So this is what is a gist of different types of IP. Even Hanish mentioned to you. So the first and the foremost in the order of priority will be patents first, always, then trademark, then designs, copyright, uh, geographical indication, and trade secret. And there's also, I think, IC in layout as well, integrated circuit layout as well here. So next slide, please. So we'll just dive into what is patent now. So of course we mentioned, I mean, we discussed that intellectual property is a creation of mind. So how will you differentiate between so many different types of intellectual properties into a patent? It's very simple. Patent is always pertaining to the technology. When I say technology, let's consider an example of an uh, network or a 2G or 3G. So the difference between here is the signals in which we will be perceiving, if I'm not wrong. So the speeds. So speed and all are the advantages to it, but how the network is working to bring about that speed is the technology here. So for such a technology, patent is the one you have to go for intellectual property protection. Next slide, Anish, please. So, with that context, there are certain rules for a patent to be granted in any jurisdiction per se. So that's the first thing is it should be new. That means your idea should be new. Then it should involve something called as an inventive step. Inventive step in India is defined in three criteria. One is either that invention should bring about economic significance in that particular technology. I'll give you an example. Bear with me, please. Then, Hanish, the slide went off. As I was saying, the first thing is the idea should be new. The second one should be uh, the idea should involve inventive step. The inventive step has three rules or three criteria to be met. The first one is to have an economic significance. Second one is it should have a technological advancement. And third one is both economical significance and technological significance. This is according to Indian Patents Act. Hello, Hanish, I'm unable to see the slide.
You can't see the slide?
No, it went off.
No?
Not yet.
Yes, sir. Your slide is off, sir.
No, actually, I'm sharing the.
Maybe you can cancel and then project it again.
Sorry?
you can cancel this. I mean, I think there will be, if it is showing as you are already projecting the screen.
Let me try. Let me try.
Yeah, reshare it again. So these three criteria should be met at least to firstly to to comply with the requirement of inventive step. Then it should be capable of industrial application. Here, when I say yeah, now it's visible, Hanish. When I say industrial application, it should be able to be made and processed in an industry. So let's consider an example of uh, say again the signal 2G to 3G signal, or even 4G you can consider. The idea of the signals being manipulated so that you get the required speed, that technology itself is considered as new now. That's the first thing. I'm a mechanical engineer at base, so I'm not so well versed with signals as such, so bear with me again. So uh, second one, the inventive step here, at least we are having some economical significance as sorry, the technological advancement here. So it solves again the criteria of inventive step. And then of course it is now being able to be used in a telecom industry. So hence it is satisfying all these three criterias. So a patent which has all these three criterias, which is disclosed in that patent, will be granted. Patent application will be granted. Now, the next point that is quite important here. See, patent is always territorial in nature. That means it is if the patent say is granted in India, it is only granted in India. It doesn't mean it is granted worldwide. So your rights on that idea only rests in India. So if you want idea to be protected somewhere, then you have to refile it again somewhere. For example, if you want to seek protection in US, you have to file it separately there. File in the sense submission and all those process like what we do in for college applications. Similar to that, we have a body. We have an office called an Indian Patent Office in India. Similarly, we have an European Patent Office in Europe, a United States Patent Office in US. So as such, every country has its own patent office. We need to submit our application there. They will scrutinize the application according to their local laws. More or less, something, a few, majority, not few, majority of the things will be similar. When I say things are nothing but the rules or the conditions, only few aspects such as formal requirements or formalities will be different on country to country basis that we need to look after, and then the patents or will be processed accordingly. So that is what the second point is. So where the patent, whenever it is granted, it's a territorial in nature. So as Hanish also mentioned, it's IP protection is nothing but protecting someone from uh, copying your idea. At the same time, you can also make and use the uh, idea which is disclosed in the patent application or the patent, and you can offer for sale as well. So that is the exclusive right you get from owning a patent. Then you can also sell or import a product on a process on the jurisdiction where you are protected with. For example, let's say you have protection, you have a patent on an engine, and you are getting it manufactured from US. So you can import that product from US to India and you can use it, and it should match the disclosure which is included in your patent. So that is the important caveat here. Of course, the term of patent is only 20 years. Thereafter, it will go back to public domain, and anyone will be able to use it. So we need to strategize here, and strategize and ensure that your patent document is valid for 20 years. That is where the challenge comes in for drafting the patent application. Next slide, Hanish, please. Hello, Hanish. We can go to next slide. I think we went a little far. Yeah, now we can directly jump on to patent search. Now, before we go to, I think this is already covered. So why patent is required. So before we go to patent drafting, it is always advisable to go for a patent search. So we'll now be going through patent search. The reason being, firstly, drafting and submitting an application is not at all a problem. Patent office will happily accept our application as well as the official fees involved with it, and they will process the patent. But whether the idea is patentable or not is the question mark. So as I mentioned again, every office, once they receive the application, will definitely scrutinize the application. The scrutiny will be based on patentability of that idea. They first check whether the idea is new or not, and whether it has an inventive step or not, and whether it is industrially applicable or not. So this check, even any attorney or any patent engineer is capable of being done, because there are a lot of tools available, patent search tools available. So it's always better to get a search done, then proceed with the drafting of the patent application. This will save generally almost, I mean, at least in Indian terms, approximately 1 to 2 lakh rupees easily, so that that money can be utilized for some other research if the idea was not found patentable. So in patent search, generally we have multiple steps involved which needs to be considered. uh, like, these are the rules kind of thing which needs to be checklisted, so that an efficient patent search can be done at a reasonable amount of time, at least, because we cannot dwell on it for a long time, because there will be new applications that will be popping up in the search engine every day, because thousands of applications, hundreds and thousands of applications are filed every day in every jurisdiction. So here, when we conduct search, the one main thing which needs to be understood here is, even though the patent is granted for a territorial jurisdiction, let's say India, the search will be conducted worldwide. That means, even though if an inventor is getting a patent protection in India, the search will be conducted worldwide to ensure that his idea is nowhere known in the world. So the novelty and inventive step is applicable throughout the world and not for India only. So that is the most important thing that needs to be understood. And once, let's say, an inventor has come up with an idea, and these are the 10 rules which we in Kris-Hagan are at least following, so that an efficient search will be carried out. The first thing is, determine the purpose of search. So what is the search? Whether are we doing, there are different types of search. That's first thing. In patent search, you can know how many applications have been filed by a company, in which field they are mainly focusing the research on, in let's say in this current financial year, 2022 to 2023. What is their current scope of research, and how many applications have been filed again? Sorry. And so far, where their focus was, how many different fields they have focused so far. And these all come in something called as a landscape search, where we are just covering how many patents have been filed by one particular entity, and over which all fields the patent applications have been divided into. Let's say, for example, Tata Group has patent applications in technology, in automotive technologies. They have patent applications in uh, say signal processing. They have in software. So how many patents are there in software? How many patents are there in automobile industry? How many patents are there in signal processing? So these kind of divisions can be obtained in landscape search. Then there is also a different kind of search called as a freedom to operate search. So that will give, like, let's say an idea has been made, and the inventor doesn't feel that a patent can be granted, but he still wants to market his product. So how so in the FTO search, what we will be doing is, we'll first search whether whatever the product the inventor has come up with is that present already in one patent application in that jurisdiction. Let's say an inventor has developed a toy, and that toy is not patentable due to some reason. It can be again the initial reasons what you mentioned, that is it's not inventive or novel, but he still wants to market this product. So for that, one way would be to check in India, if he is wanting to sell his product in India, check in India whether there is a patent application which is replicating that product. If it is not there, he can always market it and sell it and make money out of it. So that is what comes under FTO search, and there's some already there's different search called as a prior art search, as there's another search called patentability search. So we need to understand the purpose of the search first. So what we require here in our presentation today, we'll be focusing more on the prior art search and the patentability search, because that is where all the new inventors will be generally in. That is the stage where they'll be in, because they want a patent to be granted rather than going for a landscape or a prior art search. Landscape or an FTO search. So firstly, we'll understand the purpose of search. Then we'll gather the necessary date for conducting the search. Here, when we say date, when was the invention conceived? That is the point. For example, some inventors, due to their busy schedule or due to missed opportunity, will not be able to present their idea at a given time. Let's say if an inventor has come up with an idea last year and he is not able to articulate his idea, then we may have to consider the invention to be dated last year. And at the same time, along with that, we need additional data from him. What is the invention, where his technological advancement lies in. So all that data along with the date, we also consider the data, necessary data that is required. Then determine the database needed to be used. See, there are a lot of patent search tools available in the market. Either it can be a free database or it can be a paid database as well. So it's best to use both, and we use both and conduct the searches in accordance with the data gathered as well as the date in which the invention was perceived. Then based on whatever we have gathered now, we'll develop a search strategy. Search strategy is nothing but formation of keywords, or we'll ask for confirmation from inventor about terminologies, because he's in our patent space, we call a technical person as a person skilled in the art. So a person skilled in the art generally will be aware of the terms which is used in that particular technology, or in basic terms, again, it's a technological jargon. So we'll ask for such terms and then develop or form key strings. See, for example, how we search in Google, we actually type in keywords. So similar to that, we type in keywords which are relevant to the technological domain and then analyze the search results. We'll perform the search. Once we perform the search, the database will give its own will give its own ranking based, or the results will be popping up based on its ranking. So that we'll still not consider that and go into each and every document, whichever feels relevant, and then either modify the search or repeat the search. Haneesh, we can go to the next slide. Once we are getting the results, a few results which they will be shortlisted, and then we will be analyzing that. Once that is being analyzed, we'll do a short report of it, and that report we'll definitely show it to you at the once we are at the end of this presentation on patent search. We'll show that to you so that you will have an idea as to how we will be performing the search and how in depth the search will be made, generally not only by us but by most of the patent engineers available currently. Hanish, we can go to the next slide. Yeah, this is what we were talking about in just now. So categories of patent searches, there are different types, as I mentioned: landscape search, patentability or novelty search. As the name indicates here, patentability or novelty search is nothing but a search which is conducted to determine novelty or newness of this patent idea. Prior art searches just to know the prior arts. See, the patent system works on uh, the date of filing basis or first to file basis in simple terms. So whoever files first will get the patent first. So uh, so earlier you file the application, the better, because you will not give leverage to other competitors to file first. So in prior art search, what we do is before filing of a patent application, if there are any relevant documents which are already available in public domain, those will be provided in the patent prior art search. Validity search is again just to ensure the state of the art search or the current trend in that technological space, whatever is available, that will be provided. FTO we just discussed, where FTO is nothing but a freedom to operate search, where sorry, where we will be just checking if an inventor doesn't want a patent and he just wants to market his idea, and we'll just check in the search whether patent applications are overlapping with this product or not. And then it's the infringement search, which is more or less the FTO search. And then miscellaneous search can be like an applicant search, as I just mentioned, just how many applications have been filed for a particular applicant. So those kind of searches fall under miscellaneous. Next slide, Hanish, please. These are all broadly covered, the novelty search and everything. If any points are missed out, we'll just recollect it again. So Hanish, we can go to the next slide. Yeah. Here in database selection, as I mentioned, again, there are different types of databases that can be free or paid services. Generally, every patent office have their own search tool. We'll say search tool for that. So India has its own Indian Patent Office search tool. Similarly, US has one, Europe has. So we can search individually in those as well, and ensure that the particular idea is not available in that jurisdiction. So based on the requirement, we can use a different search tools. We can go to the next slide, Anish.
Can you see the slide, Santosh?
Yes, yes, I can. We can move to the next slide, Hanish.
Yeah, developer search strategy, that one, right?
Yeah, yeah.
Yeah.
Those are already discussed, but we'll if any point is missed out, we can just have a look at it.
So can we go to this slide, where to look?
Yes, yes.
Can you see this slide?
Not yet.
I think there is some delay in presenting.
Huh. Yeah.
Yeah, I've already moved to the next slide, actually, where to look.
Okay, okay.
So you are not able to view that
No.
now?
Now, yeah, now it appears. Yes, now it has come.
Yeah, fine.
Yes. Uh, this may be kind of a overlap because we wanted to cover this section in patent drafting. Nonetheless, uh, see, patent document has different sections in it. Basically, there will be drawings, there will be abstract, there will be a title, there will be a specification, and there will be something called as a claim. We will go through it thoroughly in the coming slides. Uh, but during patent search, we need to understand where we have to look. Generally, the title gives you a broad idea as to what that invention is. So if it is, let's say your invention is again on, let's say internal combustion engine, and title is about engine again. So we can have a look at it, maybe open the document and just see the abstract of it. So have a look at the abstract, understand if it is relevant, then only dive into specification and drawings. Or you can do the other way around. Just open the document, have a look at the drawings, especially in mechanical related, or mechanical or automobile related, because from drawings you can understand a lot better than text. So have a look at the drawing. If it is relevant to your invention, then have a look at the abstract and then specification, so that you will spend less time on one particular document. If it is irrelevant, then we will be just wasting time. So this is generally done for each and every document which feels to be relevant to the idea. So this is how it will be looked at in every case. If it is electronics related, or if it is computer science related, probably the title first, then the abstract, and then specification can be looked at briefly, and then we can decide whether it is whether it is relevant or not. We can go to the next slide, Anish. Yeah, so the entire process what we just discussed: do the search, evaluate, modify the search results, and repeat. So we basically just doing the same thing over and over again until we so that we know and we understand that the idea is being covered or not. We can go to the next slide.
Santosh, is it visible?
Yes, it is visible.
Yeah.
So here again, analysis as well as conclusion is what differs from the patent engineer's viewpoint than a inventor's viewpoint, because inventor generally will only look at the technical aspects, but when it comes to a purview or a like a view of a patent engineer, legal aspects also come in, because the patent draft is not only a technical document, but it's a techno-legal document. Apart from the usual technological jargons present in it, there will also be legal aspects to it, again, which will come to it later. So those aspects an inventor will be less comprehending that. The extent, even a single word in that means a lot when we put it in conjunction with the technological aspects to it. So in that sense, so we have to first look at it objectively, how the patent, whatever documents we have now obtained. Sorry, Rama, you had a query. Hello, Rama R, I think has raised a hand. If you have a query, we can discuss that. Okay, I think there is no query. So we need to be objective. Firstly, we need to individually look at the document and then compare it with the idea, and then rank the documents based on the relevancy. And this is what I meant because when we type something, Google first gives you a result which may or may not be relevant. So we don't have to rely on the search engine, but rather our decision making to ensure that the idea has been properly searched. or not. Sorry. Next slide, Hanish. So this is a sample of the result, and we can open this document, Hanish. So this is just a gist as to how we present the results. So this invention was pertaining to some rain gauge which an inventor had developed. Rain gauge is nothing but it's a device which measures the amount of rainfall that is being the amount of rain that has been now poured on a particular area. There are already existing rain gauge devices. We call it rain gauge, and there are already existing numerous rain gauges of different varieties. So this was one such variety, and inventor wanted us to conduct a search for that. So once the document opens, we'll just show it to you.
Yeah, it is open. Can you see
It's
that?
not yet appeared here, Hanish.
I think what I shall do is, I think I have selected only one tab, so it will show only that PPT. So 1 minute, I'll just stop sharing it and I'll share my whole screen. Okay, give me a minute.
Yeah, sure.
Visible now?
Yes. Okay. So this is our first. This is how our first page looks like, and this was conducted. This search was conducted last year, and as I told you, this invention pertains to a rain gauge. We can go scroll down, Hanish. So this is just a content, brief content, and this is just to navigate the client to go to that relevant document. Here, next page, Hanish. So here we firstly capture the entire invention, what the idea has been discussed. If you follow the steps, the 10 rules which we have mentioned, we'll be following all those 10 here. And in the first, second, and third points, we first mention what is the scope of search. Here, the scope of search is patentability search. They wanted us to know whether this idea is patentable or not, so that they can get a patent. And initially, we have gathered data and as well as data. Here, data is not mentioned because there is no clarity in that, but the data has been captured here, and that data is here. So we thoroughly thoroughly articulate it in this document as well. So you can go to the next slide, Anish. Now, next page. So here in whatever the drawings that inventor has provided will be mentioned here again in the document, and then explained in detail along with our understanding as well, so that our understanding is in sync with the inventor, because that is the most important thing, since we will be conducting the search. Then we will be mentioning or we'll collating the key features of the invention. So here in this rain gauge, these 5 points were the key features. The providing the plastic cup mesh, first mesh, and the second mesh, and a rubber gasket. If you see here, the sentences in which the way in which the sentences have been written is not direct. There is some legal twist to it. This is why we call it as a technological document. A patent application will be completely filled with sentences like this. If you see a plastic cap mounted onto a tipping bucket, so mounted mean if an inventor is writing it, he'll be just saying probably a plastic cap attached to a tipping bucket, or it is just connected to a tipping bucket. But mounted is kind of a broader word. So by saying mounted, we'll be covering attaching, welding, gluing, even fastening. So all these different possibilities are covered in one single word. So that is how the sentences will be crafted, and we have also done this. The same in this report as well. We'll go to the next page, Hanish. So once we have actually collated all these key features. So once we collate all these key features, we will provide a result summary as well. Based on in this search, we had actually 6 documents were procured during the search, and these 6 documents, how they were relevant was actually mentioned here. If you see, one of the rules was also that to look at it objectively. So this gives us a very clear picture as to which aspect has been mentioned and which has not, and if there is any ambiguity, even that is mentioned as not explicitly disclosed. Next page, Hanish. And then we'll explain, or we'll put in whichever are necessary or relevant paragraphs from the document in this report. So here we'll mention which the name of the document and everything. Then we'll add on the relevant text here, and also underline the text which is required, so that it's easier to navigate the report. Next page, Anish. We can scroll down. So this is how we'll be adding the content. Whichever is relevant here will be added here. Then we can go on. We can go in the last now. Conclusion. Similarly, for this document, we'll be including for all rest of the 5 documents, including the drawings which are relevant there. And then we will be now going to the conclusion of it, where we will be analyzing based on the table here. Of course, before that, this is what the key words or key phrases, because one of the rules is we frame search strategy, or we frame the keywords. And considering that this invention is a rain gauge, these are the keywords which we will be using, which were used in the search, to be precise. And also there is something called as an international patent classification. So every document which is filed, we'll come to this later again, every document which is filed will be categorized into with some code in it. And we can use that code also. If, let's say, if one document has been found within that code, we can use that code. And it's like we already know that this technology falls within that code, so it will be easier, and it is strategic to just search only in that code and then collect the results. So that is what here there was only one IPC. We call that again international patent classification, and that there's only this patent classification was used. And then these were the sources used here. PatSphere is a paid database actually that we are using, and USPTO, eSpaceNet, and WIPO and Google Patents. These are all free databases, and these were also used for conducting the search. So WIPO and all is maybe a topic for the next discussion, because that talks about a PCT application, which again makes it more technical again. So then based on all these search strategy, search results, and whatever the key strings were formed, this was the conclusion here. Based on the table here, actually combination of all these documents were able to disclose the idea which the inventor wanted to articulate. So this is how as I mentioned again, for an invention to be patentable, these 3 steps are must and should. There is no compromise here. So firstly, it should satisfy the criteria of novelty, inventive step, and then the industrial applicability. So we give a different reasoning will be given. This is what we call as objective reasoning. So as to why we feel that this invention cannot be patentable based on documents D1 and D6, and this is how it is. Yes, even if one criteria is missing from these 3, then also the invention is not patentable. That is one thing which needs to be noted. We can close this, Hanish. I think any queries so far? Any queries in patent search, or would you like to see a brief patent search to be done? We can spend 5 minutes and just show how a patent search is done. Maybe.
Yeah, I think at the end of the session, we can have a Q&A session where, anyone having any queries on this particular topic, they can come up with their queries. I think
Yes.
we can answer those queries during that time. So I
Sure, sure.
think this should be fine, right, Hemkumar?
Yes,
Hello?
sir. Yes, sir. Yes, sir. Definitely.
Yeah. So you feel free to go, come up with the queries.
Yes,
Don't
sir.
feel
Yes, sir.
Yes, yes.
I think we will just what we'll do is we will cover the topics.
Yes.
And right now, searches are the almost done. We'll go ahead with the drafting part, and then
Yes, sir.
we will open up for the Q&A session.
Yes, sir. Yes, sir. Definitely.
So we wanted the session to be more interactive, guys.
Yeah. Please
Feel free to, because see, the patent drafting involves a lot of reading and understanding. So it becomes kind of stale when as time moves on. So it's better to ask questions. That way, it'll become more interactive. So please feel free to raise questions.
Yes.
Okay, so now we will go ahead with our PPT. You can just
Sure.
complete it, and then we'll go ahead with that.
Definitely,
Q&A.
definitely. So, as I mentioned before, firstly, we'll conduct the patentability search or a prior art search and understand. Now, after gaining confidence that patent search has turned out to be positive, that invention was found patentable by either attorneys or patent engineer. And here, one caveat is, just because a patent engineer or a patent attorney is saying that invention is patentable doesn't mean that it will sail through 100%. This is just uh, giving us confidence as to like, yes, we can go ahead and file a patent and we have a pretty good chance of getting a patent. So please do not construe that just because a patentability search from an attorney is positive, the patent will be granted in patent office. Need not be the case, because the controller may construe an idea differently, and it will be a job of either whoever has filed the application to convince him to get the patent, because he has to understand ultimately, not the patent engineer. However, this will give us a very good roadmap, and or a very, uh, when I say roadmap, we'll know the route in which we have to draft the application to get the patent. Because sometimes the invention may be ABC. When I say ABC, the components to it or the features to it can be ABC. But let's say A and B were known, and only C was found to be the new thing. Then, if, for example, in out of those 5 features, let's consider a hypothetical situation. In the example which we saw for the rain gauge, there were 5 key features, and let's say the first 4 features were known and fifth one was not known, where we didn't get it anywhere in the during the search. Then we can focus our patent draft only on the fifth feature and then try to get the patent, because we ourselves now know that those 4 features are already known. So there's no point in again going back and drafting the application on that. So that is one role which we must understand before proceeding to the patent drafting. Now, what the patent draft reflects is basically the content is, we will clearly describe in the patent draft that, of course, it is novel, it is inventive, and it is industrially applicable. And of course, with examples or with relevant explanations, we will be defining all these 3, and is also patentable under Indian patent law. Here, see that the fourth point is again kind of actually we can consider and provide a separate session for that again, because there are few clauses in Indian patent law. As I told you, every patent jurisdiction has their own laws. Few such laws which are quite deviating from other patent jurisdictions are available or present in Indian patent law, and that is what the fourth point talks about. So when an invention is being drafted in India, we need to construe, we need to keep all those in mind and then draft it. Because just to give an example, Indian Patent Office considers inventive step very strongly than novelty. Novelty generally they allow, but the problem is inventive step because they never agree to inventive step. They never agree to any small changes. It will be very difficult to convince them. So, and they also require a lot more description pertaining to clarity and as such. So that's again, as I told you, for a different discussion we can consider. So the main contention here is the patent draft should comprehensively describe the invention. There's no ifs and buts here. It should be there. If it is not there, as I told you, some or the other formal objections will come in and it will become very difficult to convince an examiner of Indian Patent Office. So the draft is like a last chance kind of thing where we have the chance to explain everything about the product, whatever possible modifications can be done, whatever possible embodiment, we call it embodiments in our patent jargon. So whatever different embodiments can be captured here, what are different ways of let's say arriving at that product, all those things needs to be comprehensively described in description. And in that instance, inventor has to help the attorney, because attorney will be writing in a techno-legal language, and the inventor has to help him to provide all the details, because some of the inventors generally hesitate, and so invention may not be captured properly. So of course, as I mentioned again, with examples, the problem that is being solved. As I mentioned, I mean, again, going back to our previous slides, inventiveness or inventive step means there is a technological advantage or a technological advancement over the existing technology, and there is an economical significance, or both. So how is that achieved? That needs to be captured in description again. So yes, we are, let's say there is a advancement, but how is that advancement being done needs to be explained thoroughly. Again, in this context, there should be no ambiguity. And as I mentioned again, any technical person in that particular technology, we call him a person skilled in the art. And when a person skilled in the art, apart from you, is reading your description in the patent application, he should be able to arrive at your conclusion, whatever you are thinking of. So that is what we mean by the last point. So next slide, Haneesh. Yeah. So the basic contents of a description or a patent specification is a title, field of invention, background, and there's a detailed description. Now, there are different types of specifications based on the needs of the inventor. The first one is called as a provisional application, a provisional specification. Another one is called as a complete specification. Again, this comes into a lot of Indian patent provisions. So I'll just touch upon it. So provisional specification is always filed to ensure priority date. As I told you again, patent system works on first to file basis. So let's say the inventor has not thoroughly or completely finished his research on an idea, and he has just has an idea and he wants to protect it. And he feels that within the next year, he's able to complete the research and is able to provide complete details of the invention. To protect such idea, provisional specification will be drafted. In provisional specification, broadly, the contents will be title, technical field or field of invention, background, prior art, and only the description, not the detailed description, because the invention itself has not been researched in detail yet. So there will only be description. So, and in this specification, the entire contents of the invention so far, whatever has been developed, will be broadly captured, so that there will be no limitations to it. When I say limitation, please consider the example of the word mounted. Instead of mounted, you can always say attached, you can always say fastened, you can always say glued, but that those are all specifically attached means, or specifically connected means. When we say mounted, it will encompass, it will cover all those variations or all those possibilities. So that is what when we say broadness. So provisional specification covers the invention broadly, and it will be only based on whatever the research has been done so far. That will be filed. in the Indian Patent Office. And complete specification will have all the details of the invention, and along with something called as a claim, which will go by in the further sections of this presentation, because that is kind of the most important part of a patent application, because that is what gives you the protection you are seeking for. So we'll go to that. Meanwhile, we'll go one by one of the details of the specification. Firstly will be the title. We will show it to you probably in an example how a title looks like. It should be a concise statement, and it should not include any uh, uh, slang words. For example, brush here. Brush is a slang word kind of thing. It can be any brush. If the invention is pertaining to uh, a brush, it will be better to say it as a cleaning article rather than a brush, because that is giving, again, cleaning article can be used for anything here. Of course, it is a subjective thing. You may say brush can also be used anywhere, but a cleaning article will mean that it's kind of a roundabout way of saying the brush. Similarly, in pen can be written as a writing instrument, because it's again a roundabout way of saying. So the title includes these words, and there is a limit. Again, we cannot use go beyond 15 words in India. So we can go to next slide, Hanish. So the technical field. So I was mentioning to you about something called as an international patent classification. So once you submit the application, the patent office in which you are submitting, based on the technical field, classify your invention. That is the use of this section of the specification. You will mention as to what or where your invention falls under in this entire technical canvas that is around us. For example, if your invention is similar to that rain gauge, you will say it's a sensor. Firstly, uh, relates to a sensor device, more particular to a rain gauge device for determining or for determining the amount of rain that is pouring in a particular area. So that way there will be specific codes for each of such sections. For example, for sensors there will be one section, for engines there will be one section, for signal processing devices there will be one section, for ICs there will be one section. So accordingly it will just go there. The patent examiner will just drop this document in that particular domain. So that is the use of the technical field. We'll go to that. We'll show you an example of it. Then the background. See, this is the area where you will explain the problems existing in the current technology, and it is like substantiating your invention, saying how it is different from existing art. Basically, that's the main point of background. Here, there are different ways of writing it. Either you can directly bring in the closest search or closest patent document itself. For example, let's say you have already conducted a patent search and you know the closest patent document which was arrived at, and you already have some technical differences with that. So you can mention that, see, already there is a patent application saying so and so, which is relating to my technology, but I am differing from my technology, by so and so aspects. But you will not be writing anything about your invention in the background. It will be only about the prior art. That is one caveat which needs to be understand. So your next question will be, then how can I say that my invention is being differentiated from the background? So that will be covered in the detailed description. Saying again, you'll not be giving a detailed difference kind of thing. You'll just be saying I'm overcoming all these problems by the features so and so. So there's a difference to it. Instead of saying this is my difference directly on the face of it, we are explaining the technology and then saying that we are overcoming the problems in the prior art by so and so method or so and so component. So those things of the problems in the existing prior art and the existing prior art will be covered in the background section. Next slide, Hanish. Yeah, so you can either choose to write in prior art, And of course, it's actually not mandatory in India. As I mentioned again, each territory or each country has their own way of processing a patent application. So a few things may not be mandatory, or few aspects may not be mandatory in India, but few are mandatory in US, for example. It is mandatory for them. You have to give them some search results because they ask for it. If you don't have it, you have to say you don't have it, and that will be considered for prosecution also. So prosecution is nothing but examination stage. So it's not as of now in India, mentioning of prior arts is not mandatory, but again, few draftsmen do include, so that it will be easier during prosecution. Next slide, Anish. So after writing the background, then we'll be going into the description. Again, if it is a complete application, we'll be going for the detailed description. Here, whatever the Indian law says, let's say we are drafting this for Indian jurisdiction, or a draftsman should ensure that we are covering all the provisions of Indian Patents Act. We are satisfying those provisions. At the same time, one of such provisions is describing the best mode of performing the invention. So because there will be a lot of variations. For example, let's say the article is a bottle. I'm just giving you a vague example. A bottle which has a motor and which is able to pump water from the bottle to outside or discharge it. So the bottle shape can be anything. It can be cylindrical, or it can be of a different cuboidal shape, or anything per se. So those things, whatever is the best, that needs to be covered in the description, detailed description. Other possibilities can also be written. At the same time, best mode should be there, else there will be something called as an enablement issues. Then the best mode can be then substantiated with the help of some experimental data or some tables or graphs or any diagram per se. Then again, based on whatever details you are providing, that should enable a person skilled in the art to understand or comprehend your invention, and then be like comprehend it, and then be able to even implement it without assistance of the inventor. So that way you are actually satisfying the criteria of best mode of operating the invention being disclosed in the description. Next slide, Hanish. Yeah, so this is the most important section in the patent application, and this will be only included in complete specification. I mentioned there are two types of specification, that is provisional and complete. For the purpose of this discussion, of course, there are different types of applications based on the scope of filing and based on requirement and all. In a complete application, claims is the most important part, because this defines the boundary of your invention. This is like fencing your real estate land. So if your land is like 30-40 square feet, I mean SFT, then you only fence in around 30-40. So you cannot trespass, and you cannot, you can protect someone from entering your property. At the same time, you will not be going and going into others' property. So claims define that boundary. So here is where you have to be very careful in crafting the words, because consider the example again. If you say attached in a claim, then it will literally mean attached. Even if you say, no, I can actually fasten it, nobody will consider it, because in the claim it is mentioned as attached. So that is why here we start using words which are legal terms. For example, these are all kind of techno-legal terms. Again, mounted, configured. These are all the terms. We'll go to that. We'll show that to you. There is an example we draft here, and this will again permit an inventor for making, using, and selling, or even offering the sale for invention based on the boundary which you have defined. Then next one, and of course the claims should capture the invention again. We'll go to that. Next slide, Anish. So here we thought of explaining this with kind of a story. Consider there is a Stone Age patent office. And here you can see a grumpy old examiner, with bearded examiner, where he's just scolding an inventor. Here inventor has submitted a wheel. Here wheel is his invention. If you can see a stone wheel, so he is saying first you're talking about fire, then iron, now wheel. So you think we are here to waste time? As I mentioned, the examiner scrutinize an application. So here he is scrutinizing the wheel of this inventor. Next slide, Hanish. Apart from wheel, there was another inventor who had developed a stool. Here, as you can see, there is a slab here. This is a brief description. We'll not go into it. We have less time. So there is a short description or a short abstract of that, what his invention is. So here 2 is the area where it's a platform for sitting, and 6 are the legs which are connected to the platform, and 12 is the one which is supporting it. So here the invention was this entire chair. Next slide, Anish. So this is how then that was the initial set of, or that was the first introduction of chair into the Stone Age. So then that was of the inventor name was Smith. Here then Mr. Todd came up with a new variation of that. So here apart from the legs and the platform, Mr. Todd came up with 10, that is a backrest. So the question is, we can go to next slide, Hanish. So this was the claim which Mr. Todd applied. So hope you are visualizing. Mr. Smith chair did not have any backrest, and Mr. Todd's chair now has a backrest, but rest of it are same. So if you see the claim here, it says just there is a plank, there are a pair of poles, at least one second length Weber which is connected to the plank, and there is a cross member connected to the upper portion of the poles for the person to lean back against as the person sits on the top side of the plank. So here the claim 1, this is what we call as a claim 1. The first section is called something called as a preamble, where an apparatus for supporting a person in a sitting position above a surface. The terminologies can be changed, of course. That comprises, here instead of calling it as a chair, we are calling it as an apparatus for supporting a person. So it need not be for sitting. That's the main intention of writing such a language. So depends on the size of the person. If the size, of course, if the size of the chair is so big, you can also sleep, then you can sleep. So it's still supporting a person. So this is how we need to construe it while drafting the claim. Every such possibility, at the same time, it should fall within your invention. So that is what the agenda is in claim. Then the parts, this is purely a mechanical invention here. So mechanical invention generally have this inclusion of construction of property, or how not property, construction of the feature, sorry. So how it is placed, how it is located, how it is connected, those are generally the agenda in a mechanical related invention. So here, as I mentioned, Mr. Todd's chair has the only difference is provision of this, or providing this cross member. So in the first slide of this regarding the claims, you saw that patent examiner was a little grumpy, so he wanted to know the difference. So here when the examiner read it, what do you think? Did you think the patent examiner will allow this invention, or will actually not grant a patent for this? So what do you think? Maybe I'll give you probably 10 seconds or 20 seconds if you can answer it. Do you think the examiner will allow this application? I mean, consider Mr. Smith's chair and consider Mr. Todd's chair. The only difference is the cross member, and that cross member is mentioned in the claim. So, okay, I'll go ahead since we are short in time. Yes, this patent application was considered by the examiner because The cross member is enabling a person to lean back, which is quite a big invention at that point in time. That that is considering the invention before, this is a very big advancement. So this patent was granted. Next slide, Anish. So then Mr. Todd's patent was again changed, or again it was filed, and by including 16 is the armrest here. So this was again separately filed, including 12. 12 is nothing but the cross member. Again, this patent was examined in the same way as how we just discussed, was compared with the existing art, and the difference was and this difference was actually contemplated, was understood by the examiner, and then it was granted. Next slide, Hanish. So based on the story what we saw, or the example claim one what we saw, the independent claim generally, or the claim generally, the anatomy of it is something like this. First, it should start with a preamble, the whatever an apparatus for supporting a person. So that was the preamble here. Preamble defines where you have to look your invention into. For example, if your invention is based on an engine, then you can say an internal combustion engine comprising. If your invention is on a software, then you'll be claiming for a system which is working in conjunction to arrive at something. Then second part is called as a transition, where the rest of the body you saw, the plank, the cross member, those are all called transition parts or a body of the claim. And one more big observation here is each claim will be of a one single sentence only. Whatever paragraph you saw, it was of a single sentence. That means only when the claim ends, you'll be including a full stop. In between, there will be no full stops at all. So that is one observation. Next slide, Hanish. And then dependent claims, we didn't get the chance to show it there. We'll show it at the end. So dependent claims are something which will support the invention, which is provided in the independent claim one. These are like ancillary features or supplemental features, which can be a possibility, and these are strategically included in the draft, so that during examination, if the examiner says your claim one, before that, always remember examiners actually analyze the claims only. The description what you write, the best mode and everything are just a support to the claim. We are just explaining the claim, because just by reading the claim, most of the time you'll not be able to comprehend the invention at all. It will be that broad, and there will be different possibilities. To be more clear on that sense, description will be written, and description will, as I told, it will be supporting the claims. So examiners always compare claim one first, because that is what defines your boundary. And claim one, when he analyzes the claim one and he feels that the invention is already present in the public domain, then you can amend the claim during the examination stage and bring one of the dependent claims to independent claim one, and then seek for approval. So that is the strategy which will be employed. And here there's a very vague example. What we saw was a tool there. If the invention is about a tool, if the claim one recites a tool comprising so and so element ABC, then the dependent claim will be written as the tool of claim one further comprising some XYZ component. That is how it will be. We'll show it to you. Next page. Yeah. And the one of the most important thing is antecedents basis. See, antecedents here is nothing but usage of articles, which is very specific in patent jurisdiction or in a patent application. So what happens here is, when we say article, whichever the part or whichever the feature you are bringing in first, if you are bringing that feature for the first time in a patent application, you should mention it always with an article, with an indefinite article, basically. For example, if you are bringing gear for the first time in a description, you should bring it as an a gear. Same thing for claim as well. So because claims will be considered as a separate section in the specification, so you need to follow a separate antecedents lead there. And if you're using the gear for a second time, it will become the gear. Again, I'll just repeat it again. If you're using a term for the first time, it will be by indefinite article, and for the second time it will become the definite article, which is the. I think that more or less sums up. And once we write this, I mean, after the claims, generally there will be abstract. There you'll be just writing the invention again concisely, so that inventor or the examiner can understand the invention in the gist whatever is provided. Hanish, we can open the Word document once and we can show them how drawings and all will be prepared. This is just a example. This was written in consideration to application which was filed in India. That is why we have something called as a Form 2. See, this invention was pertaining to a gloves with an attached what to say, this it's a dispenser basically. Can we go down, Hanish, once? So it's basically for a sanitizer. Yeah, hand sanitizer generally are provided on outside, and we need to touch the lid and then pump the sanitizer into our hands. This was an invention where that sanitizer was attached to the glove in a strategic manner, and without touching any walls or any component per se, we can get the sanitizer on hand. That was the invention. We'll show the drawings to you. So in the first page, that is why instead of saying it as a glove with a sanitizer, the title was a wearable dispenser, because you can wear it and it's a dispenser. It's, again, as I told you, it's a roundabout way of mentioning the same thing, and which broadly covers all the possibilities. Then as you can see, the technical field, the first section in the specification will be technical field, and this is how it will be written. Here we are the invention relates to a dispenser, but it particularly relates to a wearable dispenser, because based on this, now examiner can directly consider this document on the relevant international patent classification. Then there will be background section. We can scroll down, Anish. Background section, actually here we have also included prior art here, as you might have seen, some US number was there. And then here we have actually not written any details pertaining to the invention, but only about the prior art, as to what are the problems and how it is structured there in the prior arts. And then we are just solving that invention, solving the problems in that invention. Then there is something called as a summary of the disclosure, which is again just a copy of claim. That was the reason it was not included in the slide. It's a copy of claim. So we can scroll down, sir, Hanish. Then there is a brief description of accompanying drawings. This is in particular to Indian patent practice. Hence, we have additional drawings, though this can be used for other jurisdictions as well. Then there is the detailed description, and here we are explaining everything, every possibility of the invention in this section. We can scroll down, sir. We can go to claims directly. So including reference numerals, everything will be written in this section, and there will be advantages as well. So that, again, few sections are provided so that we can strategically use during prosecution. This is one main thing to understand here. And there is a referral numeral table, again, for easy understanding of the examiner during examination. And then this is the claim. As I mentioned, this invention pertains to a wearable dispenser and what all components it has. So as another observation here is, it's a single sentence. There is no full stop in between. As you can see, the sentence ends at line number 15, and there is one single full stop. This is called as an independent claim. Scroll down a little, Hanif. We'll just show them the dependent claim. So this is how a dependent claim is written as: the wearable dispenser as claimed in claim 1, and whatever the subsequent modification in the feature, or a supplementary feature is what we call it. So this is how it will be structured, and this is how it will be written. And You can have multiple independent claims also, depending upon your scope of your invention. And again, it's a strategic way, because if you're filing in US, there are three independent claims allowed, but in India there is they generally allow one independent claim, and in Europe as well. And in some jurisdictions, if you are crossing the limit of independent claims, then you have to pay additional fees. So considering all that, that patent application should be drafted. Then after claims, this is the abstract. There is a limit to it, hence it is written very shortly. And then this is one of the drawings of the invention. This is the dispenser. 128 is the container or sanitizer, and when you press the plug there, the sanitizer pumps into the hand directly. So this was a unique design for arriving at this. Hence, a patent was drafted here. We can go to drawings once, Hanish, and we can just show that. So this is the invention. We can scroll down quickly, Hanish. Yeah, this is how it looks like. The drawing should include all the views which can help help anyone to understand. It's a common thing. So this is how it looks like. So we can scroll down, Hanish, slowly, and this is the pump, how it is being actuated and everything. Those are all shown here, and the conduits, how the sanitizer is being delivered, all those things are shown here. Yeah, I think that is all as in presentation per se. So if you have any queries, we can discuss now, or any doubts. Of course, as you can see, there are all different modifications are also covered in the drawings. That is, as I mentioned, the best mode and all the possibilities should be covered in the description. That is where the trick comes in writing the patent application. So Hanish, presentation wise, we are done.
Okay,
So,
I'll stop sharing the screen.
yes.
And we can go ahead with for the
Queries.
Q&A session.
Yeah, Rama has raised a hand. So you have any query, Rama?
Questions, students? So I have some questions.
Yes, yes, sir, please.
So I actually this is one pattern that you have showed. It was very nice. You explained all the dependent, independent claims. Can you again repeat what is that accidental thing that you mentioned after the dependent claim?
It was antecedents.
Okay.
Yes. See, antecedents means, let's say if you're bringing any term for the first time, any term in the sense, any term pertaining to the invention. Let's say a feature. Here, the feature was wearable dispenser. If you have seen that, if you had observed it, when we are bringing it for the first time, it was mentioned as a wearable dispenser, not in the title, but in the claims and even in the specification. So and an. A and an are indefinite articles, as you are aware. So these needs to be used when we are using a term for the first time. And then it will be the wearable dispenser. This is mandatory kind of thing as per India. I mean, not only Indian patent law, but in patent law in general. So antecedents is quite strongly looked at.
Thank you, sir.
Yeah, no problem.
And
I think students and anyone having any queries about patents, the way it is, the searches are done and how the drafting is done, or any kind of queries on IP, on any topics like trademark patents, you can feel free to ask, come up with your queries. So we'll be happy to address those.
Yeah, and we understand this is quite overwhelming because it is actually a lot of information to take in. I understand the information overload. if not anything. So
Yeah, I was pressurizing Santosh to wind it up fast because we are running out of time.
Yeah. Anna
This
Davis. Anna Davis, you have a question to answer. A question, doubt. Anna Davis.
Hi, yes.
Yeah.
Hi, thank you for the presentation. It was very enlightening. I just want to know, is there some kind of checklist that is available, to cross against while you are creating a claim of this sort?
for creating the claim,
For creating a request for a patent or an application for a patent.
yes, that actually we had discussed in the PPT. I think it is there. We can use that only. Whatever description check or the points which we had written or mentioned in the PPT, we
Yeah.
can
So
use
would you
that.
be sharing the PPT or is this available on some public domain that we can access?
It is also available in public domain. Hanish, we will be sharing this PPT. Just
we can share the PPT, not an issue.
yeah, we'll be sharing the
Okay.
PPT then. So
That'll be great. Thank you so much.
no issues.
Sir, and one more thing, like the words, the way in which whatever application we are writing a patent or drafting a patent, it should be like it should be generalized. For example, instead of a pen, you mention it as a writing instrument, whichever
Yes.
is in that particular applicable to that particular patent, right? And is it that only a legal person should draft it, or we also can make it? That's my
See,
one.
correct. Your question, I mean, it's a very good question actually. Anyone can write, draft it. There's no issue at all. The problem is if a legal person drafts it, considering the legal repercussions, if I
Yeah.
mean, if I can say, uh, just as an example, pen you can write as a writing instrument.
Yeah.
What happens when you write it as pen is the reader will be directed to only pen.
Yeah.
If it's a writing instrument, I can even consider as a pencil. Maybe
Yes.
your invention can also be tweaked into a pencil as well. But
Yeah.
since the title is mentioned as pen and maybe in some other part of the specification as pen as well, the reader or even the examiner will be directed to only consider it as a pen. So that way the scope of search will change. The way in which the examiner perceives the invention changes. So that way sometimes the application may get rejected also. So it's better for a legal person to write it, because those kind of intricacies such as pen, mentioning as pen, will be considered as an embodiment rather than a definite I mean being more definite about it. So
Sir, how to check if our invention is patentable or not, sir?
sorry, I was not able to hear you.
How to check if our invention is patentable?
Yeah, we have to conduct the search for it to be
Mhm.
patentable first, or at least we'll have confidence to move ahead. Let's say you have already come up with an idea, so we need to just understand the idea and conduct a search in either free or paid databases. Then you will understand whether such technology already exists or not. If it is existing, then there are 99.99% chances that examiner will also find this document when you file a patent application. So that if that is the case, then you will not be able to get a patent granted.
Okay.
So it all rests on the examiner. If he is not able to find it, well and good. Maybe he may grant a patent, but again, it depends. It's subjective. So, but
Yeah,
the
it's,
good
as
chance.
Santosh mentioned, it is always advisable to do a prior art search.
Yes.
Okay, so I think through a prior art search, I think it will be you'll be very clear about your idea whether it can be patentable or not, or any similar ideas are already existing globally.
Yeah. Thank you, sir. And one more question, like suppose I am filing a patent, and when does my actual the right to the patent starts? The date of application or the date of grant?
See, there is something called as a publication stage as well.
Okay.
Once you file an
It
application,
will be published.
firstly, there will be a stipulated time where your application will be published.
Okay.
Thereafter, you have to file something called as a request for examination. Of course,
Okay.
even before you can file it, after publication, your application will be examined.
Yeah.
Once your examination happens, if there is any problems, examiner will revert it to you, will tell you these problems, and then if he agrees to your arguments, then the patent will be granted. This is the flow of a patent, whatever the different things happen. So the protection for you can start from date of publication, but you can only enforce it from grant of patent. There's a difference to it. For example, let's say you have filed a patent and let's say it will be granted in 2 years. It was granted in 2 years time. Let's say you have filed a patent in 2020.
Yeah.
And you have gotten a grant now in 2022. But there is another competitor who had filed or who is selling your product without a patent in 2021 and you found it. So you can claim damages from the date of publication of your patent, but you can only claim it after your grant.
Okay.
So you have
After
to
grant is
wait
published.
until grant.
Yes.
Yes.
Yes. Yes.
So there is a small difference there. So
What is the time duration, sir, normally to get a patent published?
it depends again. Now patent office backlogs are clearing very fast. If you're going through something called as an expedited route,
Okay.
now the timeline has reduced from around 6 months to 1 year sometimes. Even it's possible. Right, Anish?
Yeah. Actually, for startups, women entrepreneurs, and
Educational institute.
there is a provision to expedite the process. You can file an early publication request for early publication and expedited examination request, so that you can expedite the the possibility of getting grant.
Okay.
Right. So we have those facilities with the patent office. This is to motivate innovations within the startups, and motivating women entrepreneurs to come up with more innovative ideas.
Okay.
So we have the provision for that. Previously, we may all know that the patent application used to take such a long time, like 3 years, 4 years, even 5 years. But now, as per the current scenario, comparing to the olden days, it is happening very fast. Like there are cases that patents got granted within an year. Those are for the very innovative kind of ideas, but comparatively it is going fast.
Okay. Sir. And one more thing, suppose I'm actually working on a product actually now. Our team is working on a product, and we are going to release it as a commercial product. Before that, suppose I want to protect the basic design or my actual circuit or the idea with proof POC. Is it possible like that?
Yes, it is possible, but we have to firstly probably discuss with you. Maybe we can connect later on. Haneesh can connect later on probably. So then we can discuss about the idea. As we mentioned, firstly, it will be always better to go for a search, understand the existing this one, and then we can proceed.
Yeah, definitely.
Right, Haneesh?
Yes. So I think we are exceeding the time.
A lot. So
thank you, sir. Thank you very much for your thing, Ramya.
So I think you people can get in touch with us. I know you can share your our contact details. So anyone having any kind of any type of queries on IP, especially on patents or any of these IP, you can feel free to reach to us, send an email to us. We will be happy to provide you with all the clarifications or any kind of thing. So it is okay.
Yeah,
you can come up with your queries. Feel free to send your queries to us.
Yeah, and thank you so much for having us,
Sangeeta.
Thank you, sir, for your valuable knowledge sharing with us. Now, I would like to invite Sangeeta to deliver the vote of thanks.
Good afternoon to one and all present here. It's my tremendous honor to propose a vote of thanks in this occasion. On behalf of Puducherry Technological University, I extend a hearty thanks to our chief guest, Mr. HANEESH Krishnan, IP lawyer, and Mr. Santosh, patent engineer, who spared their time to grace this occasion. Through this event, we had an opportunity to hear a fascinating thoughts and lecture and gain much knowledge on pattern drafting and performing prayer as such. I extend my gratitude to our respected coordinator, Dr. D. Hemakumar, for encouraging us to achieve many endeavors. I must thank organizing team for helping this virtual event successful. Last but not least, I would thank the participant for active participation. Thank you all once again.
Thank you all.
Kindly fill the feedback link which is floated in the chat box and also attend the quiz. Thank you.
Okay, thank you very much. Thank you very much, for this organization, and Mr. Hemakumar.
Thank you, sir.
Thank you very much for giving us this opportunity.
Yeah, thank you so much, and thank you for bearing with us as well.
It was nice, and we enjoyed actually.
Okay.
Thank
Right.
you.
Okay. Thank you. Take care.
Yeah, you. Yeah, thanks.
Thank you, sir. Participants, we'll actually rejoin back at 2 p.m. for the next session on POC and development of business plan. Okay, so we'll stop now. We'll come back at 2 p.m.